Hi, this is Scott Weavil, Principal Attorney with Weavil Law. Today we're going to be discussing non-disclosure agreements, NDAs. There are four basic things that you need to know about NDAs. First, what is an NDA and when do you use one? A non-disclosure or confidentiality agreement, commonly called an NDA or sometimes a confi, is an agreement to preserve the confidentiality of information and use that information only for a specified purpose. They're commonly used anytime that a business needs to share sensitive or proprietary information with an outside party. NDAs are used in all sorts of settings. They can be used when you're thinking about purchasing or selling a business to share information. They can be used to share information with a business partner or a prospective business partner. They can be used to protect the sensitive information that you share with your employees. When should you get an NDA in place? Easy answer: as early as possible, and certainly before you begin disclosing sensitive information to an outside party. Second, should the NDA protect both parties, a mutual NDA, or one party, a unilateral NDA? Except for use with employees and in certain other instances, mutual NDAs usually make sense. Although one party will typically primarily be sharing information and the other party typically receiving information, some information will likely flow both ways. Also, mutuality is helpful in protecting non-business information that otherwise wouldn't be protected. This can include things like the fact that the parties are even considering a transaction. Third, what are the key terms in an NDA? First, what constitutes protected confidential information? Second, what can that information be used for? Probably evaluating a transaction, but not allowing the other party to compete with your business based on the information that you share. Who can see the information? High-level decision makers, attorneys, financial advisors, potentially lenders, other parties. And there are also other terms that you commonly see, such as non-solicit and no hires that are designed to protect your employees, deal and transactional confidentiality, the fact that the information is provided as is with no guarantees that it's totally correct or true. Fourth, it's important to remember that there are some practical limitations on NDAs. Most importantly, you can't unring the bell. NDA or not, the disclosing party is not going to be able to recapture the confidentiality of information that's been wrongfully disclosed and become public information. That's the basics on NDAs and why they're almost universally used before sharing sensitive information. If you have questions or need help with an NDA, don't hesitate to reach out to us here at Weavil Law.